Come on up, Mr. McDonald. That's nothing funny. We don't have time for these games. Come on up.
I just go by Roman, sir.
Well, all you had to do is say I'm Mr. McDonald. You didn't have to say I'm representing him. I'm related to him. All you had to do is say I'm Mr. McDonald and come forward.
Today's courtroom isn't about guilt or innocence. Not yet. It's about whether procedure can be bent without cost. In one hearing, a defendant attempts to delay accountability by fracturing identity and timing. In another, a self-represented litigant tests constitutional language as leverage. Both believe they're preserving control. What unfolds instead is a study in how courts respond when cooperation is replaced with resistance, and how quickly legal options narrow once patience runs out.
Daniel McDonald.
Here in regards to that matter, sir.
Excuse me?
I'm here in regards to that matter.
Okay, are you said I'm here. Who is I? Who are you?
Living man.
Well, if you're talking to me, I suppose you're living. I hope you're living, unless I'm assuming. There's nothing funny. Who are you?
My name's Roman, sir.
Roman?
Yes, sir.
Hello. Are you an attorney?
Yes, sir.
Well, unless you're an attorney, you don't need to represent Mr. Daniel McDonald. You can have a seat. You said Roman,
Yes, sir.
and you're not an attorney?
Yes, sir.
What's your relationship to Mr. McDonald?
Depending.
Are you representing Mr. McDonald?
Yes.
But you're not a member of the Florida Bar?
Yes, sir.
Are you a member of any state bar?
Yes, sir.
Did you go to law school?
Yes, sir.
So how are you representing Mr. McDonald?
I would just like to ask some questions in regard to that matter, sir.
You can answer my questions regarding that matter. What's your last name?
McDonald.
So your name is Roman McDonald?
Yes, sir.
And are you related to Daniel McDonald?
I just go by Roman, sir.
You just told me that. Are you related to Daniel McDonald?
Yes, that the name on your docket is in relation to me. Yes, sir.
Well, you stood up, so I'm assuming it's in relation to you, but you're not, are you Daniel McDonald?
Yes, sir.
Come on up, Mr. McDonald. That's nothing funny. We don't have time for these games. Come on up.
I just go by Roman, sir.
Well, all you had to do is say I'm Mr. McDonald. You didn't have to say I'm representing him. I'm related to him. All you had to do is say I'm Mr. McDonald and come
I
forward.
apologize for the confusion, sir.
Okay. Has the state filed an information in this case?
No one calls me Daniel.
One moment. Has the state filed an information in this case?
Not this time, right?
All right, Mr. McDonald, we will see you next month for an arraignment, November 12th at 9:30.
Sir, I haven't entered any type of plea.
I know the state hasn't filed an information. It's not time for you to enter a plea. If the state decides to file an information, you can enter a plea at that time.
Can I motion for dismissal right now based on procedural grounds?
There's nothing to dismiss. The state hasn't filed an information. What are you dismissing?
That I put in an affidavit and a demurrer, a motion to dismiss, and it hasn't been responded to. I think the state attorney has 15 days to respond to that motion, and they have not.
A motion to dismiss what?
The cases, the matter.
The state hasn't filed an information. There's nothing to dismiss. There's nothing to respond to. If the state decides to file an information, you can renew your motion to dismiss. If you're going to represent yourself, Mr. McDonald, and if so, I'll ask you a few questions. But right now, the state hasn't filed an information, so we'll come back November 12th at 9:30, okay?
Sir, I got two more questions if you don't mind.
Yes, sir.
Is there a verified claim against me?
A verified claim?
Yes.
I'm assuming you're talking about an information. The state hasn't filed an information. That's under oath and is verified.
Are there any orders? Can I be released to orders of the court?
Were you arrested?
Yes.
You're not in jail?
Correct.
You were released on orders of the court already.
Is there anything additional, orders of the court, or just waiting on the prosecutor to file additional information?
Right. Not an
Before anything
additional
else
information, waiting on the prosecutor to decide whether or not they're going to file formal charges in the form of an information. If they do, you can enter your plea. And if you want to file a motion to dismiss, we'll set it for hearing.
Is there any reason why they hadn't filed any already?
That's none of my concern. They have a statutory period of time to file an information. And if that time comes or goes, we'll address it. But right now, they haven't filed an information. If you hire an attorney, your attorney can reach out to Mr. Patterson. If you want to represent yourself, I'll ask you a few questions next month and you can speak with Mr. Patterson about it. More likely than not, for self-represented litigants, attorneys, prosecutors only speak to them on the record. So we'll come back next month at 9:30, okay?
Sir, my only problem is I live 6 hours away.
Oh, all right. You can always hire an attorney and they can file a notice of appearance and written plea of not guilty for you. If you want to seek the services of the public defender's office, you can fill out an application. The clerk will determine whether or not you're indigent. And if you are, I'll appoint the law office of Henry Mark Sims to represent you. And Mr. Hill knows exactly what he's doing. He can contact my office and file a waiver of presence or ask that you appear by Zoom. But right now, we'll come back November 12th at 9:30.
I would, if there's any way possible, I'd like to handle these matters today.
Handle what matter?
Any matters in regard to that name. And I know you have business to attend to, so I
Yes,
won't
sir.
hold you up, but
Well, you're not holding me up. We are attending
it's
to,
not easy to take 2 days off work to be here and then nothing happened. You know?
well, I just told you what you can do. So we'll see you November 12th at 9:30.
Thank you.
You can sign this notice.
And this is the motion on the demand for the body cam footage. Is that correct, Mr. Martin?
Yeah, that's one of the things I recently filed among some others. Yep, go ahead.
All right, so this is there body cam footage, Ms. Manorino?
Your Honor, I believe there is, and if the court wants to enter a discovery order in this matter, I think that would allow Mr. Martin to have access to the video that he's taken.
All righty, so let me just make sure that there's cam. All right, so I will enter the order for discovery. And then Mr. Martin, you can request that from once you get a copy of the order, you can request that from the PD. Now, as far as the moving forward goes, because obviously Mr. Martin's going to need to watch the video to further whatever prepare for his case. So are we setting this for a jury trial, bench trial, or a settlement conference?
I'm not clear about what you said about the discovery. You just said something about I can get it from the PD after an order, so I'm not clear on what you're saying.
I can't tell you how to practice law, sir. So I can't tell you how to go about that. I'm going to enter an order for discovery,
All right.
and then you take your steps to get the discovery. All right. So
The order that I'd be given to it, if you're just going to tell me I can go to the records office and get it, that's not providing me with the information.
I'm not telling you how to do it, sir. I'm just telling you I'm entering an order whereby you'll be able to get gather information that you need to for your case. So.
All right, we'll just see when it comes in, but like I said, you're just not being totally clear on what's that going to be or whatever, but so I can't possibly object to it now. If anything, I have to wait and see what your written order says, but okay. So,
right. So we're going to set this up are we setting this for a bench trial, a jury trial?
if need to, well, first I'm object to, I don't think I can get a jury trial is won by one's peers, and I don't think that's going to be able to be obtained, because I doubt if I can find a jury of my peers, which would be those that who acknowledge as one of the people, sovereign people. Mostly everyone's probably, if not every jury member would say.
That's not how it works, bud. I'm just telling you, that's not how it works. You have to get back on Google and Google whatever other story you want to come up with. Peers just means anybody who's over the age of 18 who lives here in the city of Taylor. That's your peers, who are also registered voters. That's where the jury pool comes from. That's what the Constitution allows for. They don't have to be, when you say like-minded, that doesn't mean that they have to subscribe to some archaic form of the Constitution that isn't how it actually reads. And I'm a pure constitutionalist myself, so I get that. But That's not what that's absolutely not what it means. Not to mention, I can't tell people, I can't exclude people from a jury pool because they have a constitutional right to serve on the jury. And that would actually be violating their constitutional rights if I asked them whether or not they subscribe to some sort of sovereign citizen theory of the Constitution and then exclude them because of their beliefs. That's literally unconstitutional to do that. So what you're asking me to do is something unconstitutional. You will have a constitutional jury of your peers, as it has been declared by the United States Supreme Court of how that works. So are you requesting a jury trial or a bench trial? That's the simple question.
If I request a jury trial,
This choice feels emotionally defensive, selecting a jury not for strategy, but to resist perceived control. Legally, it's risky. Jury trials extend timelines, lock in jurisdiction, and eliminate procedural ambiguity. What feels like resistance is actually consent to the system's most formal process.
it'd be fraudulently presumed that I'm giving jurisdiction.
Say again?
If I say I want a jury trial, is that going to be fraudulently assumed by you that you have jurisdiction over me?
First off, I already established that I have jurisdiction over you. You committed a crime in the city of Taylor. I have jurisdiction over you. Court does. So we already discussed that part. You can order the transcripts from that first time when we already went through jurisdiction. If you didn't understand it from there, you can always order the transcripts and reread it. But clearly, I already have jurisdiction. So, and I don't fraudulently assume anything. Everything I do is done because I was elected to be the judge here. I am sworn in as the judge here. I uphold the Constitution. Matter of fact, I keep a copy of my oath right here on the bench. Why? Because it means a lot to me. So there's nothing fraudulent about anything that I do, sir. I will tell you this: you will get a fair trial. That's for sure. That's why, because that's what the Constitution requires for everybody to get. And so if you're implying anything other than that, that's not going to happen. So again, jury trial or bench trial, I need to set it for one or the other, sir.
Well, first, I object to the truth that you're asserting. I don't agree that that's true what you said there. But
Sure.
if we're going to force the hand, like I said, it's going to be a jury.
All right, so jury trial it is.
But I'm
So
gonna,
I'll set that. Go ahead.
It's only through fraud and duress do I say that. So that's all I'm under here, fraud and duress.
Okay. Well, first off, there's nobody. There is no fraud nor duress. You're sitting in your own home. You're on Zoom. There's nobody twisting your arm. No one's holding any weapon to you in order to necessitate a duress type of thing. And basically, I gave you a choice. Do you want a bench trial or a jury trial? So it was up to you to pick, and you wanted a jury trial. There's nothing wrong with that. You have a constitutional right to set jury trial, and we'll make that happen. So, again, nothing but due process and fairness happening here. So we're going to set this for a jury trial, and you'll be receiving notice in the mail when that will be.
Thank you, Your
I'll
Honor.
also be mailing out a copy of the scheduling order. Have a good day, sir.
I was going to say,
Happy
Thank you,
Happy
Your
New
Honor.
Year's.
you just talk. You don't give a person a respond, and then you say how something ain't threatened duress, but you don't
But
give
you know, when I make a ruling on something, a ruling is literally, there's no response to it. That's what the ruling is. So the ruling is, I'm going to set it for jury trial. Your motion for discovery is granted. I'm going to send out an order for the discovery, and there's really no other response needed other than Happy New Year. You'll get your date in the mail for the jury trial, and you'll get a copy of the order in the mail.
that's clearly obviously unfair to say there's no response. That's saying what I say is that, and that's it. There's nothing to say about it. Obviously, you don't believe in the Constitution too much because you're not giving me my due process right to say what I have to say. Meaning,
Well, first off, listen. If you're just gonna needlessly jabber about things that have nothing to do with anything of the case, you've already won your motion. So I'm not really sure what more you need to make a record on. I literally said, hey, we're going to enter an order for discovery. You requested discovery by a motion, and I'm granting discovery. So there's really no more record to be made other than if you want to say something like, yay, I won, or something like that, but there's nothing more to add to that. If it's about the facts of the case, this is not the time or the place to talk about the facts of the case. That's what the whole point of a trial is for. And then you can prove your case to, well, you don't have to prove anything. The prosecution has to prove their case. You can present things or you can remain silent. You have the right to do that. You can be a witness for yourself. You can do that if you choose. So with regard to that, that's how we're going to proceed. And then, so we're going to send out again the jury trial notice in the mail, and you'll receive it at that point. In the meantime, stay safe, have a blessed day, and a happy New Year, sir.
Nothing dramatic happens in these courtrooms, and that's the point. The defendants are focused on language, timing, and perceived leverage. The judges are focused on structure. That imbalance matters. Courts don't punish confusion, they document it. Every deflection, every premature motion, every attempt to argue theory before jurisdiction is settled creates a record that works against the person making it. In the first case, the attempt to delay through identity confusion doesn't stop the process. It accelerates judicial control. The court clarifies who is standing before it, sets the next date, and removes any illusion that filings alone trigger dismissal. Procedure only activates once the state acts, not when the defendant demands it. In the second case, constitutional language is treated as a shield instead of a framework. The judge doesn't argue ideology, sana. He narrows choices. Bench or jury. Proceed or wait. Once that choice is made, it's no longer philosophical, it's procedural, binding, and reviewable. What connects both hearings is a misunderstanding of power. Courts don't need agreement to proceed. They only need jurisdiction and time in these rooms always favors the system. Every missed opportunity to streamline becomes another required appearance, another mailed order, another step deeper into formality. Nothing here explodes. Nothing escalates. But something important disappears quietly: flexibility. And once that's gone, every future decision becomes more expensive in time, effort, and outcome.